are trying to portray what future may hold in terms of intellectual property and patents and what you should stay away from, what you can't say?
Yeah, I guess I'll just make a comment on that. It's very important to have either a confidentiality agreement in place or a non-disclosure agreement in place, and I guess I would suggest it be drafted by a competent attorney to make sure that you have covered all of the bases. Another thing to think about is, if you're having a discussion with a third party and you do have some, core ideas or inventions for the company, does it make sense to file a patent application, whether it's a provisional or utility application, get those on file before you have these communications with the third parties to make sure you're thoroughly protected. And if you can't do that, then it's important to have the non-disclosure agreement or confidentiality agreement in place.
I think what I would add to that is, first think about what you have to disclose. Because if you're talking to financial investors, you probably don't have to disclose much about the technology. In fact, they probably don't want to know much about the technology and want to know more about the opportunity from a financial standpoint. And I've sat in many, many investor meetings where as soon as they start talking technology, that's when I see smartphones come out. So, you have to think carefully what really needs to be disclosed. And I think developers of technology spend most of their time talking about why it's really cool and how great this invention is and what are the nuances with it, and lose track of the business side. And they have a tendency to want to disclose more and more about the technology than they really need to. And so what I would caution is, obviously,